Good afternoon. My name is Jessica Tillipman, and I am the Assistant Dean for Government Procurement Law at the George Washington University Law School. Thank you for joining us for today's webinar, Combating Fraud in Government Procurement, sponsored by the GW Law Government Procurement Law Program. Today, we have over 570 registrants for our program joining us from around the world, demonstrating that there is indeed a lot of interest in this incredibly important and timely topic. Before we kick off today's event, I want to take just a minute to mention our next free webinar coming up in February. On February 15th at 12 p.m. Eastern Time, the Government Procurement Law Program will be co-sponsoring a program with the GW Law National Security, Cybersecurity, and Foreign Relations Program. The event, titled Ethics and Integrity Under Fire, will feature Michael K. Atkinson, the former Inspector General of the U.S. intelligence community. As many of you may recall, in 2019, the world first learned about a whistleblower complaint alleging that then President Donald Trump had abused the office of the president by soliciting foreign electoral interference in the 2020 US presidential election. The complaint triggered a formal investigation, which ultimately led to the first impeachment trial of Donald Trump. The high-profile investigation was led by then Inspector General for the U.S. intelligence community, Michael Atkinson, and put an international spotlight on the whistleblower protections given to members of the intelligence community, the critical role of inspectors general in the United States government, and the challenges of navigating a high-profile investigation in the midst of a political firestorm. We'll discuss these issues and more during that free webinar on February 15th, and I'll put a link to the registration page shortly after we introduce our speakers today. Now, for today's program, it's widely known that fraud in government procurement is a global problem. Indeed, it's estimated that annually trillions of dollars are lost to fraud in public procurement. In the United States, the federal government has been using a powerful tool, the False Claims Act, to prevent, detect, and mitigate procurement fraud since 1863. The False Claims Act has come a long way since then, now used to recover billions of dollars annually in fraudulent claims submitted to the US government. What has made this law so impactful? A few things. First, it's driven primarily by an exceedingly powerful whistleblower provision, referred to as its qui tam provisions, sometimes pronounced qui tam, but I'm going with qui tam, which incentivize individuals with original knowledge of statutory violations to disclose this information to the government. Qui tam whistleblowers, also known as relators, can receive a portion of the government's recoveries, typically between 15 and 30%. Given that the FCA provides for the recovery of treble damages and civil penalties ranging between, and this is in 2021, $11,803 and $23,607 per violation, the recoveries can be significant. Second is the expansion of this statute's application. Most people would agree that if a contractor has knowingly mischarged the government or promises to provide a particular good or service, then knowingly substitutes different or inferior goods or services, that can constitute fraud. But the FCA is also regularly used to combat companies' failure to comply with contract or statutory requirements. Although most government contractors are well aware that they're required to comply with these myriad obligations when they do business with the US government, some new requirements, including new cybersecurity compliance requirements and even the contractor vaccine mandate, although frankly, I'm not sure where that is in litigation right now, have ensured that the impact of the FCA will only continue to grow. Today, we are delighted to welcome three False Claims Act experts who represent key stakeholders in this area of the law. First, Sara McLean is an Assistant Director of the Commercial Litigation Branch, Fraud Section, Civil Division of the Department of Justice, and is also responsible for leading the implementation of the department's Civil Cyber Fraud Initiative. Second, Cleveland Lawrence is a partner at Mehri and Skalet, I hope I pronounced that right, Cleveland, apologies, based in Washington, D.C. He is co-chair of the firm's Whistleblower Rights Practice Group and also an alum of the greatest law school of all time, GW Law School. David Robbins is a partner and co-chair of Jenner & Block's Government Contracts Practice and also serves as Jenner & Block's representative on the GW Law Government Contracts Advisory Council. Okay, with that being said, we're going to go ahead and get started. And I'll take the first question and toss it to Sara and ask you as a general rule, and I believe this question is a little bit like, what is the meaning of the life? But has the False Claims Act been an effective tool for combating fraud in government procurement?
So I would say definitely yes. First off, I should say that my comments, although I do work for the Department of Justice, my comments are my own. I'm not speaking on behalf of the Justice Department here today. But I'm sure the Justice Department would agree with me that the False Claims Act has been incredibly effective. And in particular, in its current form. So there were major amendments in 1986 to make the quitan provisions that allow whistleblowers to come forward more effective, and to provide to make it easier to be a whistleblower and to be rewarded for being a whistleblower. And since that time, the recoveries have been incredibly impressive. So in procurement cases, the False Claims Act has recovered $8.65 billion since those amendments. And I would say, you know, the dollars are important, but also I think that is, which it should not be lost sight that also has enforced sort of the integrity of government programs and encouraged compliance and deterred fraud by others. You know, as Jessica was talking about the different types of cases that we see in the procurement context, you know, some of them are about overcharging, but some of them are about product substitution. I mean, we're talking about, you know, flares that don't work, weapon sights that don't do what they're supposed to, you know, bulletproof vests that don't function properly. And I think, you know, in addition to recovering the funds that have been recovered, it's important that those cases have been pursued. The False Claims Act is, you know, some misconduct can be pursued criminally, some misconduct can be pursued administratively or using a contract remedy. But I think the False Claims Act is a uniquely powerful tool when you have a situation where a corporation has acted with reckless disregard or deliberate ignorance. That's not necessarily a matter that would be pursued criminally, but as a law enforcement matter, it can be pursued under the False Claims Act. Treble damages and penalties can be recovered, and it's important that we do that, and it's a powerful incentive. When I joined the office in 1999, we already had about 70 attorneys. We have 134 now. Before those amendments that I mentioned in 1986, we had a handful, I mean, 8 or something like that. I mean, at the time when I joined in 1999, those people still worked in the section, but it's the quitan provisions that really led to a huge increase in the number of cases. Today, we get 600 to 700 per year. And I think they've been extremely effective in pursuing the overall mission.
Can I give a slightly different perspective, but not a defense counsel perspective? I wear a couple of hats today, right? Just because we want to keep this to a manageable size. Prior to rejoining private practice, I worked for the Department of the Air Force, and among other things, acting suspending debarring official. Let's put that to the side. But sat as their procurement fraud remedies coordinator, which under empowering instructions, it told me I was supposed to stay in close contact with DOJ, with investigating agents, and with the programs that the Air Force ran that were victimized by fraud. The question on the table is, has the False Claims Act been effective for preventing, detecting, mitigating fraud? No doubt, it has been effective. But we do need to keep in mind the lens through which this is perceived. Because the government programs that are arguably victimized, in many, many cases, given the length of time these cases proceed and how long they take, don't actually get the financial benefit. They don't. The money goes back to the US Treasury, not the affected program, which then has to reprocure, engage new funds, find new ways to meet their needs. It's not an automatic back to the affected program. So effectiveness is sort of subjective. I think the commander fielding particular weapon systems might have a very different answer than what Ms. McLean just said, because they are the ones stuck trying to make things work. However, there's no doubting the deterrent effect that large False Claims Act, either judgments or settlements, have in this arena.
I had an excellent student last year, LLM graduate, who wrote her thesis on kind of the effectiveness, and her argument was there's still so much fraud. So how can it really be seen as effective? But I think ultimately, and one of the things that I stress from day one in my anti-corruption and compliance course is you can never eliminate fraud or corruption. All you can do is at best prevent, detect, and mitigate it to the best of your ability. So I think that's an interesting perspective. Cleveland, let's turn to you. What do you think?
Yeah, of course, I agree that the FCA has been incredibly effective at reducing and mitigating fraud. I think it's somewhat difficult to quantify sort of the overall deterrent effect. We certainly see repeat players in the False Claims Act arena, and so there's probably still some work to be done to prevent fraud on a massive scale. But I do think that during this proliferation of time since the sort of modern False Claims Act came into effect in 1986, we've also seen this gradual movement toward corporate compliance programs and acceptance of whistleblowers on some level within the company. And I think sort of that effect on industry as a whole is another way that the False Claims Act has proved effective, not just at recovering money, but changing culture. So I think that, and I also think that we're seeing that model being replicated throughout government. The IRS has revamped its whistleblower program. Dodd-Frank has introduced, two very strong whistleblower programs for the SEC and CFTC. Some 30 states have adopted, their own versions of the False Claims Act. Those principles are being adopted at the Department of Transportation, the Department of Treasury. So we're starting to see, the idea of rewarding whistleblowers take hold in lots of government industries, proving the effectiveness of the False Claims Act.
It's interesting you mentioned that because as much as the model has been replicated, as we've seen in different areas, exactly as you've said, Cleveland, we've seen that in different agencies with the different statutory regimes, also at the state and local level, what we call the baby False Claims Acts in different states. We don't see, we see whistleblower protections expanding outside the United States, but it's interesting to me that internationally, we have not seen this kind of embrace of bounty programs or whistleblower reward programs replicated to the same extent, and indeed often rejected outside the United States. And and for those of you that are joining us outside the United States, feel free to add a comment or question to the chat about that function, because that's always been interesting to me, that it's proven to be such a great incentive, and it's been such a powerful driver of False Claims Act recoveries to have these bounty programs, and why that has been kind of not adopted similarly by other countries. So food for thought. Oh, Sarah.
Can I comment on that? I mean, I think an interesting thing with how the False Claims Act works in this country is the reward to the whistleblower, on the one hand, encourages people with very good inside information to come forward, and that can make for very good cases. But honestly, you don't have to be an insider at all to be a whistleblower under the False Claims Act, and you honestly don't have to have very good information. So not all whistleblowers fall in that category where the information they brought is what is incredibly helpful to the process. I think in our country, what they bring, whether they have good information or not, is the assignment of an attorney from my office and potentially an attorney from a U.S. attorney's office whose responsibility is to pursue fraud, who then teams up with the Inspector General's office for the affected agency whose responsibility is to pursue fraud, and who then reaches out to the agency, and as David was describing, the commander in the field who has a lot of other responsibilities that are not to pursue fraud. And it's partly the assignment of those other people who then drive an investigation that might never have been launched that leads to the recovery. And that has been started by the whistleblower. I'm not sure if in other countries, legal systems are so different internationally, where you have, judges acting as investigators. That's just a completely different kind of construct than how we do things here. So I don't know if those dynamics would play out the same way, but I think that is part of part of why the False Claims Act is so effective and the whistleblower provisions are so effective here.
Yep.
And
Oh,
I
I'm sorry,
would
Cleveland,
just,
go ahead.
I just add to that, Sarah, for the international community that generally speaking, there aren't any prohibitions on international whistleblowers in any of the US laws or programs. So non-US citizens certainly can be whistleblowers under these laws and programs. So, employees who are serving internationally, who have information about wrongdoing committed by, US companies may want to keep that in mind.
Or foreign companies, actually.
Or foreign
It's
countries,
a very good
certainly.
point.
So this great strength that was just identified by my fellow panelists is also a tremendous weakness, in my view, of the False Claims Act. And here's where I'm wearing both hats of the Agency Fraud Remedies Director, former, and Defense Counsel. Right? We spent a long time when I was with the government trying to provide incentives for the acquisition workforce to identify things that are actually fraud, right? And bring forward proactively these items that are actually fraud. We had real trouble with that because the interests are just not aligned, both because of what I spoke about earlier and because there is perhaps a slightly different understanding about what a business mistake and the normal friction in a contracting process is there at the buying agency as compared to when people with perhaps their own pecuniary interest might come in and amplify what could be just a normal business friction to try and generate a big case, perhaps a big recovery. I am not trying to denigrate the people who see true fraud, criminal or civil, and bring it forward. They're incredibly valuable participants in the system. But I think this set of incentives, especially as it proliferates, makes it a lot harder, especially given the misalignment of incentives within the government to generate what the buying commands care about and what the buying commands can raise their hands about and say, this is actual fraud. We want to do something about it. I fear we are trending towards an increasing outsourcing of that obligation. Granted, that's the purpose of the False Claims Act, but it is also its greatest challenge, I think.
And I would respond that I don't consider this function to be outsourced. I consider Sara and the Department of Justice to be a partner in False Claims Act enforcement. I think that, that partnership aspect gets lost a lot, and that it's important to keep in mind that the relator who brings that case is really looking to the government to support them as a whistleblower, but is also prepared to, prosecute those claims without the government if necessary. And so it's a big undertaking, to file a lawsuit with your name on it, to say that you are going to stand in the shoes of the government if necessary.
One of the greatest things that I saw when I ran the DoD NASA Procurement Fraud Working Group or co-chaired it, we brought in a whistleblower, a relator, who told us about the challenges that he faced and his family faced, just the retaliation after he brought his suit forward. He told us of his family living in a car, not sure how they were going to make ends meet. And this particular person was vindicated at the end of all of this. So I do want to make clear that I am, of course, playing in part a role today, making sure you see the various different interest groups to call this forward because it's an important dialogue. And I want to make sure it doesn't come across as callous disregard for true whistleblowers, true believers with real problems that they bring forward.
I guess on your point, David, about encouraging the acquisition workforce to come forward with, to pursue fraud where they see it. I guess I wonder if these things, if whistleblowers bringing suits impedes that, or, is there a reason why those can't both be proceeding at the same time? We certainly, the Department of Justice welcomes referrals from agencies and gets referrals from agencies in addition to getting whistleblower complaints. And I agree with you that it's very important for us to be pursuing what our agencies consider to be the problems. I think that's an extremely high priority. But it seems like we should be doing both. And I guess I wasn't sure if you were saying that the existence of the QTM suits somehow is making it more difficult to get folks in agencies to identify fraud cases.
I think it does. Oh, I'm sorry. Please
Yeah,
continue
why
the
is that?
question.
No, can you explain? Mhm.
Yeah. Both anecdotally from speaking with
Sure.
former members of your office over time and speaking and working with dozens of federal agents and also working with the buying commands, their time is so taken up by these efforts that may or may not generate recovery within a lifespan that is material to them. And there is, and forgive me, you gave a 35 or whatever year span of billions of dollars in recoveries. As I see the recoveries, it's almost a declining sine wave over that time, since the ill wind driven changes to major fraud against the United States and the Civil False Claims Act on into the future. And I'm sorry, on towards the present. The recovery just isn't there to justify the time or the effort. And it's really difficult. I had this role to try and provide incentives for commanders with stars on their shoulders to dedicate command time taken away from warfighting missions, for example, to spend on this when they never see a return. So I just think it's a combination of the perhaps tremendous number of not terrifically high dollar recoveries that have gone through the system in the last 5-10 years, right? And a crowding out effect it has elsewhere, because there's almost a learned behavior that, well, if we don't get anything out of this, why should we put anything into it? And for the record, I think that's the wrong approach. I think aligning those incentives goes a really long way. But obviously, the Department of Justice exists to punish, the buying commands exist to buy. And that's a structural challenge we have here in this country.
I didn't want to know if I should dip my toe back in and let you guys talk a little bit longer.
Well, but you must have thoughts on this, Jessica. I don't know if you want to moderate or offer some thoughts, but it'd be welcome either way.
I'm being neutral on this topic, and I'll move this
Well,
to the next one.
I guess,
enough.
I mean, I'll say, I understand the point that you're making, and I think that's interesting, and you have a much better perspective on what's going on within the agencies, especially
Just a
DOD
different
than I do.
perspective.
Well, no, but I mean, you're closer to the buying commands as you describe it, so I appreciate your thoughts. I guess, I hearken back to the years before I joined my office when nobody worked there because there were no cases. So I'm not sure that, I don't know what the answer is to your problem. I mean, one part of the answer certainly could be, is just sort of an appropriations answer. Why are the buying agencies not getting more money back from cases when there are recoveries? I mean, the False Claims Act provides for treble damages partly so that Cleveland's clients, the whistleblowers who've been living in their car, can get paid. So that we can be paid for the cost of investigation. It's supposed to compensate for some of these things, but I hear what you're saying, that it's not necessarily compensating all the people who are being made to work on these cases within the government. That doesn't seem like necessarily a sort of fix to the False Claims Act that's needed, but maybe it is a fix that's needed. Because I don't know how people are not necessarily aware of this, but if the way that it works, if we get a recovery, we can return the single damages to the agency. So the idea is that the agency should be made whole. But I mean, and David, maybe you can elaborate on this. I guess if the appropriation is no longer open because too much time has passed, then the money needs to go back to the Treasury. So the government does get the money, but what David is referring to is, do the people who are actually trying to run the government program at issue get the money back in their budget? And the answer is not necessarily.
You explained it perfectly. That's precisely it. And that is the incentive feature, truly is the incentive feature. I know Jessica probably wants to move us along, and we could just totally nerd out on this topic, because I agree with you. There is a legislative fix that's necessary. Like, I really wish pending amendments, which I know we're not going to ask anyone who works for the Department of Justice to talk about, didn't make materiality, easier to prove or harder to disprove, and instead gave an incentive to the government, the buying commands, to actually benefit from here. I think that might have the effect that's being sought, not the one the amendments say. It's the right reaction. Yeah. Sorry for bringing it up, Paul.
So we did get an interesting comment that talked a little bit about how in other countries there might be an issue where the bounty might not be able to cover security, and that's a whole other bigger issue why maybe it hasn't been adopted. And so ultimately, again, it provides for the people in the car. As we say, we're now it's not even a straw man. It was a real person that was living in their car, but the hypothetical person in the car. So let's move on to some other issues. So let's move on to kind of the expansion of the application of the False Claims Act. It's not even expansion, we've had these, but of course, for those of you that are kind of newer, there was a major case several years ago, Escobar, which formally recognized this theory. And I'm not going to go down this. I cannot explain implied certification theory in 5 seconds. As I tell my students all the time, many of the statutes we learn in my anti-corruption class are a walk in the park compared to the False Claims Act, which is complex and complicated. But it effectively blessed this theory of implied false certification. It also got down to this concept of materiality, because as we know, and I said at the outset of this, there are myriad obligations that contractors have when they do business with the US government. And in this Escobar case, Justice Thomas really spent some time talking about how do we use, like trying to distinguish between using a very powerful tool like the False Claims Act with, you know, very hefty penalties and treble damages to deal with these, the failure to comply with these obligations, and comparing that to just a routine breach of contract claim. And this theory of this concept of materiality has really emerged as a bit of a star in all False Claims Act litigation these days as to what is material when we're dealing with a failure of compliance. You know, what do we look to determine materiality? Whether the government continued to make payments on the, you know, pay the claims, is that a feature? Yes, usually a very important one. How the government responded when learning of this non-compliance. So a lot of this is all tied together, and the impact it's had on this litigation. So that leads me to a question that led to a big debate in my class this semester, which is, when we're dealing with these expansive requirements, and I want to start with Sara on this because of your role implementing the civil fraud initiative in the Justice Department, when you're dealing with these requirements, incredibly complex requirements. Let's put aside government contractor cybersecurity compliance, which, you know, we've seen in some litigation people have raised. The complexity and the difficulty with complying with these things, and whether their failure to do so really is fraud, or is it something less than fraud? Should the FCA be the statute used with these stiff penalties in these instances? And the other question goes to other complicated requirements like the vaccine mandate, where, I mean, truly, as of what time is it now? At 12:30 Eastern time, what is the status in the courts of the contractor vaccine mandate? Might have changed in the last 5 minutes, given all the litigation. So I guess I turn to you, and what is the role of the FCA? And I also want to hear from all the stakeholders' perspective when we're dealing with these incredibly cumbersome, challenging requirements that, frankly, many companies, not all, many companies are just trying their best to comply with. So I'll start with you on that, Sara.
Yeah, so, I mean, I guess if we limited the False Claims Act only to, you know, the situations where we get a bill and the bill has a number on it that is too high, or bills us for something that, you know, we didn't get, you know, here's your tank and you didn't get a tank. That would be a very, very narrow application of the statute. So in the case that you're talking about, the Supreme Court recognized that no, claims can be false for other reasons as well, because they violated other contract requirements. That doesn't mean that every contract requirement is going to make the violation of every single contract requirement is going to make a claim false. You know, submit your bills on yellow paper and it's submitted on white paper. You know, that is not necessarily, you know, that kind of thing is not going to be enough. But, you know, we have to, but it has to be broader than just, you know, I'm overbilling you, or I'm giving you the wrong thing, because there are contract requirements that are extremely important that are not going to be right there on the face of a claim form. Like, I mean, for example, you know, guards, you know, when you hire guards to secure a military base, you expect them to meet your marksmanship requirements. I mean, that's a core requirement of the contract. And if you're putting people out there and calling them a guard and they don't, you know, if you're supplying bulletproof vests that don't work, you know, it's not some contract violations are going to be enough to make a claim false. So then the Supreme Court said, well, how do we figure out, you know, what those are? And they focused on this materiality inquiry, and they also focused on knowledge. And I would say, when you're talking about the kinds of requirements that you've named, you know, cybersecurity requirements, is every mistake in compliance with a cybersecurity requirement going to be enough to turn that into a False Claims Act violation? No. But there are going to be requirements that are material to a contract, that are material to payment, And there are going to be breaches of those requirements that are reckless or with deliberate ignorance, not just mistakes. And I think those are appropriate types of violations to go after with the False Claims Act. We really cannot protect taxpayer money and the integrity of government programs if we don't go after those requirements. So, I mean, I think it's important, and I'm not sure that there's really been a proliferation of government requirements. I think the False Claims Act has evolved considerably. You know, it was a Civil War era statute. You know, we're no longer bringing cases about lame mules. As you know, I suppose it's humanly possible, but I mean, it has evolved with the way that government expenditures of funds have evolved, and it will continue to do so. So I don't know that it's any more complicated now than it's really been in the past, but we do have to sort through, you know, which requirements actually matter to the government. That's what we're trying to get at. Also, I would say there are requirements that could be violated that are not going to cause any damage to the government. In that case, the liability under the False Claims Act will be for potentially a penalty for each false claim submitted, but not for some sort of astronomical treble damages. So, you know, each case is fact specific. You have to analyze it in accordance with the elements. Was it knowing? Is it material? Or are there damages? And there's no sort of one size fits all answer to that.
Let me ask you, look back to materiality. And one of the things that I thought that was fascinating in my class, I have a lot of acquisition professionals in my classes, was the kind of concept of their impact, what they do next, having such a tremendous impact on False Claims Act litigation. And I guess one of the issues that was raised, and I know what my response was, but I'm curious what your response is. You know, a contracting officer, let's say for the sake of it being 12:34 p.m., that the vaccine mandate is standing. I don't know if it is. I literally, and you know, you have a contracting officer that doesn't believe in the vaccine mandates and just decides not to pay or to continue payment and ignores it. Or, you know, we tend to look at that as one of the key indicators of materiality. It's not the only one, but it's one of the key indicators of materiality. What happens? You get, you know, you get people that just continue payment. How does the government take that into account where you've just got people continuing to pay these things because the contracting officers just doesn't believe in it?
Yeah, I think fortunately most procurement requirements are not things that people either believe in or don't believe in, but it's a little less exciting than that most of the time. But yeah, I mean, what the contracting officer thinks is a huge factor in investigating a False Claims Act case. What they think, what they've said, what they have, you know, conveyed to the defendant. I mean, the sort of most extreme scenario is where you have, you know, if you have anyone from the government, this can happen in healthcare or some other, you know, other areas as well, who has told the potential defendant that it's fine, go ahead, you know, submit that. I mean, at that point, do you have knowledge on the part of the defendant, or does the defendant think that it's okay? I mean, you know, it depends. It's fact specific. I mean, I've had situations where, you know, the contracting official for the government was actually in a criminal conspiracy with the defendant. So I'm not saying that it's necessarily you know, and that person has gone to jail and the government is still there looking to the defendant for its False Claims Act money back, you know, and treble damages. So I'm not saying it's a get out of jail free card, but yeah, those are important questions. There's also case law though that says, like, good contracting officers, government officials, they mess up. Like, you know, the False Claims Act is partly designed to protect the taxpayer from, you know, mistakes. The harried, overworked, you know, person on the other end of receiving, you know, government funds. So, you know, we see those cases too, where the contracting officer may have done something that they shouldn't have, but there's still a good case.
Cleveland, do you have thoughts on this? Kind of, Sarah says the contracting requirements have not expanded. But what are your thoughts on this, at least from a plaintiff's perspective?
Yeah, I think that, you know, the False Claims Act is not a good vehicle for rooting out corruption. You know, there's sort of waste, fraud, and abuse. When we get into the abuse aspects of you know, government spending, where, you know, a contracting officer is complicit in a fraud, then it becomes a more difficult case to plead as a False Claims Act case. I think that the materiality question was supposed to be answered in 2009 when the definition was changed to make it an objective standard. And Escobar sort of alludes to the reasonable person standard, but then focuses a lot of attention on what the government does or did. And I think the natural tendency test was designed to take focus off of what the government did, or not require the government to have to say, yes, we were defrauded, yes, I was asleep at the wheel and allowed this to happen. But at some point, I think Sara is right that that relationship changes, where the government's not being victimized, and where the defendant doesn't have to make false statements in order to perpetrate the fraud. And Escobar also talks about not only the government's conduct, but the defendants as well. And typically I see some effort to cover up the fraud, and I think that is often overlooked as a signal of materiality, that the defendant was aware that this mattered to the government and sought to hide it from the government in some way. I think that's one of the linchpins of materiality that sometimes gets lost in the shuffle, as so much focus is put on the government's knowledge, which is usually only knowledge of the relator's allegations that are now being investigated. It's knowledge of allegations, not necessarily knowledge of ongoing fraud. And I know that the government sometimes has opined about its own reasons for continuing to pay. There may very well be strong policy reasons, despite the government's actual knowledge, to continue making payments to a contractor while also pursuing False Claims Act remedies. So I think Escobar doesn't always get to the heart of the materiality question. There are other factors that are sometimes overlooked as well.
David?
So as usual, I have a slightly different perspective, but just we're talking about procurement fraud. We're talking about it, and frankly, there have been moderators here who have made statements that may give the impression that there's an awful lot of procurement fraud. Look, during my tenure in an acquisition support function, not an acquisition lawyer, but the procurement fraud function, there were hundreds of billions, many hundreds of billions of dollars of procurement spend that went through. An extraordinarily small percentage was tainted by deliberate fraud. And that deserves all the punishment the US government can throw at it. Full stop. There is a larger, but still small percentage where all of this is debatable, where we spend an awful lot of time and government time and contractor time and resources and dollars investigating, and there's no intervention, the cases go away, or there's an extraordinarily low dollar, I'm going to use a phrase that I know at least two of our panelists will hate, nuisance value settlement, to avoid continuing to pay people like me, right, to defend these things that add no value, in my view, to the procurement system as a whole and only impose costs. It drives out potential contractors. It drives up the cost of additional goods and services that the government seeks and needs. So I guess, though my perspective is wildly different, I do agree very much with what Cleveland mentioned, that the False Claims Act isn't a clean fit here. And back to the point of the question, the tremendous expansion of contracting requirements and compliance obligations thrown in. Like if you've looked at a government contract, as we all have, it's like this big. What you actually do is about that big. The compliance is about that big, right? This all costs, and especially, I'm jumping topics wildly, but especially if we're adding in sub-regulatory guidance as a potential source for false claims, right? I'm really worried about what we're doing to the overall cost and efficiency of the acquisition system here. Leading with my perspective, I'm a defense counsel now. We're not inexpensive, but we defend companies an awful lot, and it's our job to prove that these are normal business mistakes. I see less deliberate fraud because, just to me, I don't particularly like to take those cases, right? I still remember what wearing the white hat felt like, and that's important to me. So I just wanted to share that perspective because I don't want it to get lost as we're talking, especially to an international audience, that fraud is somehow an always prevalent, universally applicable scourge on the procurement system. My experience is the opposite. It's an extraordinarily small percentage of an otherwise really well done acquisition system in this country.
I'm enjoying Sarah's facial expressions. So, and which the
I'm
audience.
glad to hear
yeah,
it. I'm glad to
I think-
hear it.
I think you can only see like one of us at a time. No, I mean, I think David raises another issue that we wanted to talk about today. And again, I encourage everyone, I think it's easier to keep an eye on your questions through the Q&A function, but you're welcome to do it through the chat as well, because we're going to reserve time at the end for questions, your questions for the panelists. But David mentioned sub-regulatory guidance, and that is a huge issue. For those of you that have been following this, under the Trump administration, we had the brand memo, which really was a directive to not use, agency guidance or sub-regulatory guidance as a basis for bringing FCA cases. And then as soon as we have the new Biden administration, Garland kind of chucked that out the window. Would that be a nice way of saying it? The brand memo, no more, that there can be some reliance on sub-regulatory guidance for FCA cases. And I know that causes some concerns among companies because of an increasing reliance on sub-regulatory guidance. Anyone that doesn't believe me just needs to Google the term DoD PGI, and you will find all sorts of little nuggets in there that provide some sort of, a lot of the instructions are for the contracting officers themselves, but guidance that could be relied upon in interpreting certain things that don't have the force of a regulation or a statute. So I guess that leads to the question, another one, putting Sarah back in the hot seat. And then I also want to talk to Cleveland about this too. What role should agency guidance play in these cases?
So I think that agency guidance is often very important in these cases, particularly if it's agency guidance that's been given out to industry, because at least it puts industry on notice of what the agency thinks a rule requires. I do not think that before the brand memo or after the brand memo, Department of Justice attorneys are making False Claims Act cases out of sub-regulatory guidance. I mean, I think that the brand memo ended up creating some skirmishes in district court, where even though it actually said that it didn't give any rights to anybody, it was just guidance for attorneys on how they're supposed to do cases. We would get arguments in court that we would then have to respond to about whether we're using sub-regulatory guidance appropriately in this case or inappropriately, and it created sort of collateral sideshows, in my view, that were a distraction from actually going after fraud on the government. So I think rescinding the brand memo makes sense from that perspective, but I do not think that it has resulted in some situation where government attorneys are now taking, a phone call that a contracting officer made to somebody telling them to do something and saying, because you didn't do that, you've submitted false claims to the government. The claims are going to be false because they violate a statute, a regulation, or a contract. But communications but I mean, and really, the government has to communicate with folks who do business with it about what it wants them to do, what it thinks these requirements mean. I mean, it's very helpful to have a back and forth. It's very helpful for, DOD to be instructing contracting officers about what rules mean. So there is going to be that kind of guidance out there, and it's going to have a place in False Claims Act cases, but I don't think it's going to have, and it has in the past or will in the future have, sort of an inappropriate role in imposing obligations on contractors that didn't already exist.
Cleveland, do you have a sense of whether the plaintiff's bar, how would you proceed with a case that somebody argued was based on this? I mean, maybe you probably tell me right now. We wouldn't do it based on what Sarah just said, but I don't know if you had thoughts on this particular topic.
Yeah, I do. Sometimes sub-regulatory guidance is incorporated, by specific reference into a contract relationship that a government contractor has with the government. And in those cases, that guidance is absolutely material and essential to that relationship. I think that it's extremely rare, and in my practice, certainly not the case that key TAM relators are filing suit alleging that liability is based on a violation of sub-regulatory guidance. I think that guidance is often used to help establish scienter, to help establish, what the industry knew about, the interpretation of a regulation. But I don't think that it's a rampant issue that folks are filing suit based on the agency's interpretation to establish liability itself, unless that interpretation is baked in to the contractual relationship, and that oftentimes is the case. There's a handbook that tells you what the statute means for purposes of this contract. I think that in those instances, sub-regulatory guidance is absolutely a proper basis for False Claims Act liability.
And then it's a contract term, and that's the sort of skirmishes that I'm referring to that we used to have to get into with defense counsel sometimes when the brand memo was in place. It was like a fight over, is this appropriate or not appropriate? And we would say, if something is a contract term, it's a contract term. It's not just sub-regulatory guidance, but it led to a lot of collateral discussion.
My challenge with the sub-regulatory guidance, my fear with the return of the sub-regulatory guidance is not the imposition, the start filing of a False Claims Act case or the beginning of an investigation, but rather as we're midway through and we're sussing out what at least is fairly prevalent in my experience is communications with government procurement officials, contracting officers who solely control the relationship and what's bought and how the contract will act, given one set of guidance, hopefully memorialized, sometimes not as perfectly as we would like. And then we see these sub-regulatory guidance with shifting and inefficient application come out, and we end up fighting almost academic theoretical battles about whether this should continue in a False Claims Act case rather than just be a pure contractual recovery, because all of this is really uncertain and it just adds to the cost concerns I raised earlier. I recognize fully everything that you've said and agree wholeheartedly. Never seen a case filed on at least not a good one, on the basis of sub-regulatory guidance. And I can't imagine your office, Sarah, getting excited by any of that, right? What the difference is, there are really capable, like Cleveland, really capable relators counsel out there who write pretty darn good complaints and really spell out what's required and where people missed on things. And there are complaints that don't and make tremendous leaps and then try and use sub-regulatory guidance later as a crutch to amend deficiencies in pleading. And just wearing the defense counsel hat, that's a concern for me, but we'll see how this evolves over time.
I didn't know if any of the other two panelists had thoughts on that, but
I highly doubt it.
I'm looking at faces and I see no. Okay, I do want to leave time once we get past the 1 o'clock, once we get to 1 o'clock to start getting to some of these great questions and comments that we're seeing. And again, so please add them to the Q&A if you have them. So I think this was one of the most interesting topics. All right, so I'm going to start with Cleveland on this one. What, if anything, do plaintiffs' counsel wish that defense counsel or even the government knew? Like, if you could share some thoughts, this is your moment. What do you wish they knew that you think that they probably don't know?
Maybe not something that David doesn't know, but I think something that I would probably reinforce to defense counsel is that, good internal corporate compliance programs are probably the best way to reduce the number of whistleblower cases you have to deal with. In my experience, the overwhelming majority of whistleblowers who, make their way to an attorney have, made many efforts sort of internally to try to stop whatever practice it is that's ongoing that, they think arises to fraud on the government. When a company doesn't have that outlet, or when that outlet is specifically designed to sort of out the troublesome whistleblowers, and it turns into a retaliatory tactic, that's when whistleblowers find lawyers and recognize that there may be False Claims Act cases. So I think that the best way to eliminate key TAM cases is to give, encourage and support whistleblowers internally. What do I want to tell to Sara? I do think that, sort of talking about memos, that, there was a time when the Yates memo, was issued, I guess, 2014 or 15. And, DOJ was putting more emphasis on, non-monetary functions, deferred prosecutions, suspensions, and debarments, as I'm sure David is very aware, corporate integrity agreements, a lot of other ways to complement False Claims Act enforcement to ensure that, fraud being busted isn't, just sort of a cost of doing business through damages and civil penalties. And I think, the Yates memo didn't, have an opportunity to really get up and running, to sort of incentivize companies to avoid, increased liability, including criminal liability, by cooperating and disincentivizing individuals to get involved in fraudulent schemes to begin with. And I think that, there's an opportunity to reinvigorate some of those non-monetary functions and to complement the overwhelming, success of the False Claims Act at getting money back, and maybe, through some of these other avenues, deter more fraud and prevent more fraud from occurring.
I just want to echo what Cleveland said. There was I have yet to find another study performed that is as good as this. It was back in the day. It's not even called the Ethics Resource Center anymore, but they released a kind of study and included data on whistleblowers. And you looked at the percentage of people that actually go outside the government. And it's incredibly small, that the vast majority of whistleblowers actually try to deal with the issue and raise the issue internally first. And it's only after they attempt and fail, that the company fails to address the issues, that do they tend to go outside and go to, Cleveland or go directly to the government, or whatever it is. So there is I think a mistaken belief or assumption that whistleblowers often are just out to get the money, and that, but in reality, many times it's an incredibly courageous act. It's something that somebody has lost a lot of sleep over before they decide to report, and ultimately wind up going to somebody when they feel like the company is simply not listening. Another real quick fact before I turn it over to this question that I like to share with people when we talk about, so if my students are in this class, you got to close your ears because we actually talk about this in class, is the percentage of complaints that actually come in on a hotline. A hotline is incredibly important, but realistically, the vast majority of whistleblowers first report to their direct supervisor. So if you're not training your mid-level supervisors or even senior level supervisors to recognize somebody that's doing a report, it usually doesn't come in a gift wrap package that says, this is a report. It's usually somebody relaying some concern that they have and being able to identify it. People need to, that's where training comes in. So Cleveland's point about compliance is huge. And there's been a huge shift over the last 15 years in what companies are doing in investing. And it's not just from an FCA perspective. A lot of it has also been driven by the FCPA as well, with these expectations for corporate compliance. So for anybody that's coming from companies out there, compliance, it's a good thing. Okay, I'll go with David on this next one. What do you wish Cleveland and Sara would know?
Well, let me preface this by saying I see my firm as having network issues. So if I become unable to be heard, just mute me and go on. I'll rejoin you when it recovers. Look, I've raised my concerns on this talk. I do think that the Department of Justice writ large needs to understand what the acquisition people are telling defendants. And it's very, very different than the positions that the Department of Justice takes in many cases. And these are the people who are supposed to bind and control the contracting relationship. The moment DOJ gets involved, no GS-12 or GS-13 is going to stick their neck out. So they just sort of turn around and DOJ marches in and says, it's our job to enforce the way things are. That's all fine. I get that. I get the statutory mandate, but it does go to materiality. It is relevant, and I do think it gets a deaf ear, probably an improper way of saying the thought, but that really probably needs to carry a bit more weight. We could waste an awful lot of time and resources in getting precisely there in the end in a way that has deleterious effects on the acquisition system as a whole, and the ability of the company to go forward as a going concern, given the thin margins in government contracting. But they get that, right? I know they get that. They're doing their job, and I respect it. And I really don't have any thoughts that I would share with really quality relators attorneys like Cleveland, because I agree with everything you just said, that internal compliance programs are key. Responding to people who raise issues, even if their issues lead nowhere, explaining that they have been heard and what the outcome is, I agree, it's vitally important. To the broader Relators Council, I would hope you do your diligence and actually understand the acquisition system and the procurement rules at play before filing a bunch of lawsuits. I have seen a lot lately of what I would consider lower quality complaints, and not that there isn't a kernel of truth or goodness there, it's just not expressed. And that, I don't think that serves anybody's interests, because that really is a drain on the broad system, and makes it harder for companies to say, you know what, there might be some there, maybe we come to the table and have a settlement discussion early and get you your recovery and get your clients their recovery.
That was the kindest way I've ever heard someone explain like poor lawyering in my life. So well done, David. Sarah, what do you wish your fellow panelists would know?
Okay, well, I would echo what David said, that I don't think my fellow panelists need me to share these thoughts with them, but I'll share thoughts that I wish certain other defense counsel and maybe certain other plaintiffs counsel be more aware of. I think on the defense side, the value of settling a case. I think a major mistake that I see made by defense counsel, which I think is a mistake for them and for their clients, is rather than recognizing that there's a problem and putting a number on it and offering some sort of a settlement and getting to a quick resolution, they create a situation where DOJ is now continuing to investigate, finding things that were not even the things that the relator necessarily brought to the table. And a problem that could have been a smaller problem has now become a larger problem. And a lot of money and resources are going into litigating something to get to essentially an outcome that could have been achieved early on by resolving the case. And Cleveland mentioned the Yates memo. One thing that encouraged was credit to corporations for cooperating. There is a provision in the Justice Manual that governs what sub-regulatory guidance to ourselves about what DOJ attorneys and assistant U.S. attorneys are supposed to be doing, that says we can give credit to companies that come in and cooperate. I think there are all kinds of ways on the defense side for a False Claims Act case to be resolved early and in a way that's sort of mutually beneficial. So I guess that is sort of the sentiment I would share with the defense side, but again, I don't need to share that with David. On the relator side, I would share, and again, I don't need to share this with Cleveland either, that when David has spoken a lot about cases that are not particularly good cases, I mean, most quitam cases do get declined, notwithstanding that I've already spoken about how valuable quitam cases are, and there are many that are great cases. There are a lot that are not good cases. And it's not that the whistleblower the whistleblower wouldn't necessarily be aware of the problems with the case. It's things like you go talk to the contracting officer and they say, I've been telling him it's fine to do that this whole time. Okay, that is not a good case. Usually the Department of Justice tries to talk to we always try to talk to the relator about cases when we decline. And I would suggest to Relators Council, again, not Cleveland, that they listen carefully to that conversation. And that if they do pursue a case that the department has declined, which certainly is their right to do under the statute, and there may be very good reasons to do that in some cases, that they stay in touch with the department so that we can keep an eye on sort of the development of the law. I think we get a lot of bad court decisions in cases that we have declined that have weaknesses in the facts, which we know, and which sometimes have been communicated to the Relators Council, but for whatever reason have not resulted in the case not being pursued. And, you know, they say bad cases, bad facts make bad law. I think we certainly see that. And it's in our mutual interest on the plaintiff side of the case, the governments and the relators, to not have that happen. So I guess that would be my pitch to Relators Counsel.
And before we open this up to questions, and again, Q&A or chat, if you have them, please post them. You know, we see potential changes on the horizon. Senator Grassley, who has been really a champion of whistleblowers in the Senate, has proposed some amendments to the False Claims Act. But putting aside his specific proposals, I guess if I could ask each one of you in turn, if there's a particular area of the FCA or the government's approach to fraud more generally that you would like to see changed, or you think is a weakness, something that you wish was different, what would that be? And that's on the list of, so hopefully you know this. I don't know if anyone wants to start first with their wish list. One thing, maybe one or two. David.
Sure. I would like to see recoveries go back to affected agencies. I think that would help the process dramatically.
All right. Cleveland.
I definitely think that this materiality issue needs to be clarified. I think in terms of wasting resources, this is a huge waste of a lot of resources on all sides to try to get some clarity on what was essentially dicta in a Supreme Court decision, but has become sort of the overarching issue of the day now. I also think that, and this is another issue that is up to the Supremes right now, the scope of Rule 9B is starting to rear again, and you know, will require some clarity. You know, I think I've always thought that there was an opportunity to clarify the rule itself in its application to False Claims Act cases, but it seems that maybe the courts are going to do that for us.
And if I can ask you just for 2 seconds to expand on the waste of resources with materiality, are you referring to, for example, you know, the defense counsel trying to seek a lot of information about what the CO has done to demonstrate materiality or to lack of thereof? Is that where do you consider the waste of resources at this point?
Well, I was sort of in a veiled way referring to, you know, I think attempts to use government resources inefficiently, and the government, I think, is aware of that, and you know, there's been some discussion around another memo, the Granston memo, you know, about reasons for the government to seek dismissal of key TAM cases, and whether or not sort of, you know, burdensome discovery requests, you know, might be one of those reasons, and so I do think that because Escobar shifts a lot of focus to the government's activities, that there is, you know, sort of an overarching focus on burdening the government with questions about what it was doing, despite the fact that, you know, the allegation is that the government, you know, was not aware that it was being defrauded. You know, the materiality issue has sort of become the dog wagging the tail wagging the dog here.
See, I used to be a TUI release official for the Air Force in these cases, and they are burdensome requests, but I don't necessarily share the view that relators and their counsel really know what the government was privy to or not. So, I mean, unfortunately, we have this law, right? And this is an essential component of both proving the elements and proving either government knowledge or materiality on the defense side. So I'm not sure we have a way around it. Maybe this just proves the point that the False Claims Act isn't a keen fit for a lot of these issues, and maybe some contractual remedies might do better.
I would add that the burden of the discovery is not just what did the contracting officer do, because I think in most cases that's going to be pretty well vetted. You know, that's part of the case. You know, what happened with this particular contract, this particular relationship between this defendant, this government on this, you know, this government official on this contract, but the discovery can go well beyond that. What did the government do in supposedly similar cases? I think that is where it's that discovery that can get extremely burdensome on materiality.
Did you have any thoughts on an area?
So,
that
yeah,
You're
I'm not
looking
gonna-
at an eye roll.
I'm not going to speak to amendments, but I think that if I could make a legal change, it would be to get rid of this movement in some cases to where courts have ruled that where a provision, a requirement is ambiguous, the defendant can win even at the motion to dismiss stage by pointing to the ambiguity without any kind of exploration of what the defendant actually thought at the time that would go to the defendant's knowledge. So there have been some cases that have said if the defendant can come forward with an objectively reasonable interpretation, if the government has not warned the defendant away from that with some sort of authoritative guidance, then there can't be scienter. And we've, for a variety of reasons, that's, I think, incorrect legally, because the defendant can still act with reckless disregard and deliberate ignorance. But I think the thing that's most dangerous is the suggestion that it doesn't even have to have been a contemporaneous interpretation. If the defendant did make a mistake, if they had an interpretation of an ambiguous requirement, they made a mistake, then of course they're not going to be liable under the False Claims Act. But at the motion to dismiss stage, where you have a complaint that's alleging that the defendant didn't make a mistake and it's got facts in there to support knowledge on the part of the defendant, the fact that defense counsel, talented defense counsel, can point to some ambiguity in the rule after the fact should not be a defense, should not be a complete defense at the motion to dismiss stage to a False Claims Act case. And there have been a few decisions out there that have sort of headed down that path, I think, very, very wrongly.
Thank you. Okay, let's turn to some questions. So the first question came in fairly early that asked, basically, isn't it fair to say that the False Claims Act is an effective tool for promoting compliance and incentivizing relators to identify and report instances of non-compliance, but it does not fundamentally move the needle on preventing fraud? Said differently, most of the settlements in public procurement are not matters of scienter or fraud, but instead reckless disregard and negligence. I will say, does anybody have thoughts on that?
Well, I'll start. I think that, when we're talking about sort of the knowledge standard, there is a difference between negligence and reckless disregard. I think an important distinction. So, while we don't have a knowledge standard under the False Claims Act that requires a showing of intent, sort of the deliberate, fraud that David was speaking about, the standard isn't so relaxed that it applies to mistakes or negligence, even I would say, sort of, gross negligence. There has to be sort of, this looking away, in the face of reason, not to. I think, sort of shirking a responsibility to ask questions. The False Claims Act doesn't tolerate, the thought of plausible deniability. Don't tell me, I don't want to know. If you have reason to ask the question, then you have to find out. And I think that that's a big distinction when we're talking about non-compliance due to negligence and what amounts to fraud under the False Claims Act.
Yeah, I think that's really important, and I think I don't agree that that the settlements are about negligence. I mean, I don't dispute that a lot of settlements are situations of reckless disregard or deliberate ignorance, but I think that having enforcement around corporate reckless disregard and deliberate ignorance of material government requirements is really important to having a well-functioning procurement system. So I think that is a sign of the False Claims Act's effectiveness.
So moving on to the next question, I think we sort of touched on this briefly about the cyber fraud initiative, but this person works in cybersecurity procurement and wants to know if there's anything unique about this application of the to the False Claims Act. Do we see it as a different kind of avenue than we would see under traditional, FCA cases brought under, certification theories?
Right. No, I think that's a very good question. And I would say, no, it's not unique. The point of the initiative, and as Jessica mentioned, I'm leading the implementation of it at the Justice Department. The point of the Civil Cyber Fraud Initiative is to use the False Claims Act to enforce cybersecurity requirements, but it's not imposing any new cybersecurity requirements. And the same things that will make a False Claims Act case a good case from our perspective in the cybersecurity realm are the things that we've been talking about. We need falsity, we need materiality, we need knowledge. We'll be looking for damages. And I think that I would say part of the point of the initiative is the law enforcement point that I just raised. Really, it's an effort to encourage compliance, deter non-compliance, create a level, protect the integrity of government programs so that contractors that are doing what they're supposed to be doing in this regard are not spending a lot of resources on that while other people are getting away with not doing it. There are a lot of goals to the cybersecurity initiative that go well beyond bringing back money for losses to the government, which is, of course, that's what you get at the end of the day is money. But I think a broader hope for it is that it will complement the rest of the government's and really the nation's cybersecurity effort.
I would just add to that. I think, to Sarah's point, I don't think there's anything unique about how the FCA enforces, contractual and statutory obligations related to cybersecurity. I think that the cybersecurity realm sort of brings together, a lot of different types of procurement fraud issues, from pricing to contract specs, and sort of quality issues to, Buy America and, Trade Agreement Act issues that are, over exacerbated when we're talking about cybersecurity and countries that we don't want, necessarily to trade with. Not only is it a problem if, the chips that get installed don't work, but it's a bigger problem if they came from China and make us susceptible to hacking or other issues of grave concern especially at this time. So I think because of the range of issues that are presented, it's fortunate that we have a specific initiative to combat that fraud, because it's, I think, going to touch so many different areas.
I think it's also an example of sort of what David was talking about, where it's an identified need within the government has identified this as a problem that needs to be pursued. Now, back to David's point, whether an individual commander considers it to be the top of their list for all the other things they have to do, that'll remain to be seen in a particular case. But this is an area where the government wants to pursue these kinds of cases, but also where the partnership with relators, I think, can really pay off, because insiders with technical expertise could be really, really important to success in these cases. So hopefully we're able to do sort of both of those things that we talked about. On the one hand, we'll make effective use of the whistleblower provisions of the False Claims Act, and on the other hand, we'll be pursuing the government's agenda because this is a government priority.
So let me just turn to one question. I'm kind of going to rephrase it a little bit. It talks about thoughts on enforcement areas. There's so many new companies getting into public procurement. And we can only expect more will enter the market as we see, infrastructure spending, changes coming out of grants, other sorts of things, people that are new to it. So I'm going to actually ask this question of David, if your internet holds. You get a new client in front of you that wants to enter the market, and obviously the FCA is going to be an issue for them. But I mean, is this the primary area where you're telling people to be cautious, or what would be your 5-minute spiel, even though clearly it's not 5 minutes?
My spiel is the image I gave to you all earlier. This is your government contract. This is what it tells you what to do, right? What to deliver, how to deliver, where to deliver, how much it costs. That's really important. Please don't forget the rest of this. It can get you into trouble. So you really need to have systems and processes and controls for this, and production issues down here. You can't forget this, or else we're going to have a much more expensive discussion later. That's the talk.
And here's the bill.
The bill for that is nothing. That's less than 0.1. That's no charge.
Um, so somebody asked a question about the FCA's incorporation into the FAR, and there are references to it, the FAR, particularly also about disclosure obligations for credible evidence of violations of the False Claims Act. And I think somebody else also asked about compliance program requirements for companies. Who do they have to show them to? What are those requirements? So just reading those two together, there are compliance obligations if you're a government contractor of a certain size, performing certain types of government contracts. We could spend a whole class, and indeed I do, on disclosure obligations. Generally speaking, compliance programs are a factor that the government will consider in settlement. It can result in declinations, reductions in fines and penalties. There's credit given for pre-existing compliance programs. But as a government contractor, even if you're required to certify that you do in fact have, if it's applicable to you as a contractor, you have you're required by law to maintain an ethics and compliance program. It's not like the contracting officers coming to your, your office to go verify it. It really becomes an issue when something goes wrong, and then you have to demonstrate to the government that you have a pre-existing compliance program, and any enhancements that you've made in the face of your compliance failures. So there's a whole complicated dance in the mandatory disclosure and the ethics and compliance requirements. There are very few countries that affirmatively require commercial companies to maintain these, and France is one of the few with CEP2. So that was 2 seconds on ethics and compliance obligations. One question we got that I've actually been asked several times now, the implication or the use of data analytics to bring procurement fraud cases or in identifying these cases. Sarah, can you talk about that, or maybe even Cleveland in your work as well?
Sure. So data analytics is definitely something that the Justice Department has been trying to rely on more and more. And I will say, the greatest use of it right now is in the healthcare area. There's just tremendous amounts of healthcare data. I think that procurement situations maybe are a little less susceptible to it. The cases seem to be more, a lot of times the cases seem to me, from where I sit, to be more one-off, less of a sort of a patterns where, for example, in healthcare, you can see, so all these folks are billing the same code. Why is this one billing it so many more times than everybody else? You can look for trends like that. I don't think that in procurement, it lends itself so easily. You've got different contractors who have contracts to do different things, and sort of the patterns don't necessarily jump out quite the same way as they might in healthcare. But it's something that we're exploring in a lot of different arenas, and I think certainly, are interested in, and would be interested if, Cleveland's clients had some kind of information that came from a source like that.
Yeah, where I've seen sort of data analytics, as a basis for building a case and consulting with potential clients about potential public disclosure issues and the like. That's primarily been in the healthcare fraud arena. I think data analytics, come into place a little more in the procurement arena on the damages side. Once the liability theory has been established, sort of extrapolating that, to cover damages beyond what the relator might personally be able to see, or if you're talking about a timekeeping fraud scheme or something, there may be a way to use data to determine how widespread that scope is. But in terms of data and that type of investigatory tool as a basis for building a case, I haven't really seen that use as much in the procurement world. So, all those number crunchers out there, feel free to give me a call.
Sarah, I want to circle back about a question that deals with the cyber fraud initiative. And the question is whether the prospect of fraud liability might actually discourage victims of cybersecurity breaches from rapidly disclosing it because, they know they have obligations, but they're now scared of a fraud action too. Was this, obviously speaking in your own capacity, is this a consideration of the government's, is that there might be a deterrent effect?
Yes. So, the goal, as I mentioned, the purpose of the cybersecurity and the cyber fraud initiative is to complement the government's overall cybersecurity efforts. So, the last thing the government wants to do is deter, immediate incident reporting, which is a really important part of the government's cybersecurity effort. By bringing False Claims Act cases. But I would say, on that score, it's, disclosing a cybersecurity incident is not, that does not mean the fact that there's been a breach or the fact that there's been an incident does not mean that there's been a False Claims Act violation by any means. When very, very powerful forces are out there trying to get all this sensitive data. So, we certainly understand that, and we're not looking to bring a case anytime there's been a breach and anytime there's been an incident. In fact, one area where we would be interested potentially in bringing cases is where there are incident reporting requirements that have not been followed, because that is such an important part of the government's cybersecurity response. So I think that not reporting an incident would be more likely to cause trouble than reporting an incident, which is not to say that, it's not to say, of course, an incident could be reported where there's been absolutely horrendous, cybersecurity measures. And it's not, there's no sort of immunity that comes from reporting an incident. But I think, I think it's not likely to, I think there are many, many reasons to report an incident anyway, including that it's required and that, the problems can be solved and remedied quickly. But I also think even from the perspective of a False Claims Act case, it's more likely to seem like this is a company that's acting in good faith, that's trying to do things right, if an incident is reported than if it is not. But yeah, it's a concern and it's a tension. I think there's often sort of carrots and sticks out there, and definitely the False Claims Act is the stick around cybersecurity.
That's true. All right, so I think we have time for one more question before we wrap up. So agencies who have failed to properly oversee contractors create an environment for fraud to evolve. How do we address agency reluctance to support and in some cases undermine False Claims Act cases? Whistleblowers are often caught in the middle. I don't know if anybody that just jumps out. This feels like a David question, but I don't know if Sarah or Cleveland have thoughts on this.
Sure, I'll jump in. Certainly, and representing whistleblowers, we sometimes run into problems with the affected agencies, lack of cooperation, and that can be for a variety of reasons. But I think there's a little tension, between justice's role sort of on behalf of the taxpayer and justice's role on behalf of the agency. And I've had lots of clients battling back and forth with justice as the liaison for the agency, that the client is essentially saying isn't upholding its responsibilities, and justice feeling that its role is to serve the agency as its client, will then say that there's, a problem with the Ketam case because, we don't support that case. And so there certainly is a role that the agency, can play to really disrupt, a viable Ketam case. And that's, what the materiality, definition was supposed to try to address was, the problem of an agency official having to, testify to, yes, I was, the, ineffective, government official who was duped and allowed, a major fraud to occur. agencies sort of still, due to Escobar, play this role that ultimately puts them in a conflicted position. And I think that sometimes, does, place the whistleblower sort of in the middle of this conundrum where they know that what occurred, violates, the rules or the contract, but the agency isn't supporting that for its own reasons.
I don't know if we want Sara to respond or do we want David? Or can Sara respond?
Well, I mean, I think, the Justice Department has to, of course we represent the taxpayer. Of course we do speak for the agency to some degree in these kinds of conversations that Cleveland's talking about with Relators Counsel. But I would say, if an agency really doesn't support a case, I mean, the discussion of why the case is not one that should be pursued is not just about because the agency doesn't want to pursue it. I kind of question whether it's a viable case at that point. I mean, I think maybe there could be some circumstances where a case is viable, even though the folks who would be the agency witnesses who would be called on to testify to the jury about the program and the problem and, the relationship are not supportive. I guess there could be situations where it's viable. There could be more situations where it's viable at the district court in front of a jury than where it's viable on appeal. But I think there are just very real legal problems with that case. And so, that I think that should be kept in mind in terms of the Justice Department's position about whether the Justice Department is going to pursue it and whether it makes sense for anyone else to pursue it either.
David, any closing thoughts or are you just gonna?
I have nothing to add. I think it was covered very well. The only thing I will add is thank you for having me in my somewhat outsider perspective compared with Mr. Lawrence, Ms. McLean, Dean Tillipman. I really appreciate it. I think it was really helpful and a broad, wide-ranging discussion, and I certainly learned a bit today too. So thank you.
Thank you. I appreciate the chance to talk to all of you. I did too. Learned a lot.
This was great. Thanks to all of you guys.
And thanks to everyone. I know usually after the lunch hour, people have to get going. So I thank everybody that joined us today for taking time out of your busy schedules. It was always interesting to read your comments and questions, even though we can't get to all of them. And especially to our esteemed panel. Thank you for taking time out of your very busy schedules to join us. It's truly a highlight of the program to hear from experts such as yourself and a highlight for our students and alumni and other friends of the program. So thank you, everyone. And the recording will be available on our YouTube channel shortly. So thanks and have a great day. Take care.
Thank you.